Thank you, Michelle. Thank you, Nate. Welcome, everybody. Thank you for joining. We do at Stanton IP Law Firm. My name is Thomas Stanton, the managing shareholder here, and we do an IP over T webinar series. And so we thought we'd do something different this time. We invited a couple of great guests, another attorney, Rochelle Walk with Aegis Law Firm, and Nate Lind, who has a vast amount of experience within the e-commerce industry, and I'll let them both introduce themselves in just a minute. But what we wanted to do today is really address the topic of e-commerce, the intellectual property elements around it, and issues that concern that, as well as the merger and acquisition side of it. There's an enormous amount of activity around acquiring and selling e-commerce sites, particularly on Amazon. Certainly you have it on Shopify and some other platforms as well. And we see with our clients a lot of questions that come up. And so what we tried to do is consolidate several of those questions down into what we think are the most important topics that you'll find the most interesting, and try to put that together in a hopefully a nice, compact, but also educational and informational webinar series. So with that, as I said, my name is Thomas Stanton, the managing shareholder at Stanton IP Law Firm. We do pretty much what that says: patents, trademarks, copyrights, and we do that both on the transactional and litigation side. And let me turn it over to Rochelle Walk to introduce herself and her firm, and then Nate to kick it off.
Okay. Hi, I'm Rochelle Walk, and Tom, thank you for initiating the idea of doing a joint seminar today. I think it's great. I am with Aegis Law, as Tom mentioned. Aegis Law is a full-service business law firm. We have attorneys in, I don't know how many states in the US, and our client base is literally all over the world. One of our major specialties, and my in particular specialty, is serving as a general counsel and counseling companies that are involved in technology or e-commerce businesses, and with a heavy interest in transactional work, mergers and acquisitions, partnerships, operating agreements, and the really the overall process of selling products and services over the internet. It's been something I've been working on for about the last 10 years. I've been, working as an attorney for over 35 years, and 10 years ago decided that I would venture into the world of online businesses. With that, I had the great opportunity to meet Nate Lind, and I had already known Tom from prior activities. Tom and I work together quite often, especially when we need a patent attorney. And I got to meet Nate because he works as, he's both an entrepreneur, as well. He's often a spokesperson and host of his own YouTube channel, and he's also a broker with Website Closers. And I'll let him introduce himself a little bit, but we've worked together quite a bit on various transactions, and I thought he would be a great addition to this discussion. Nate?
Thank you very much, Rochelle and Thomas, for the invitation to join you guys. Yeah, my name's Nate Lind. I have been an e-commerce entrepreneur for close to a decade in the health and beauty space. I was looking to actually buy a supplement company, 12 or 13 years ago. It didn't pass due diligence, but I really liked what I saw. I ended up starting one myself. Fast forward about 10 years and 9 figures worth of gross sales, a whole lot of headaches, lots of frustrations and failures. Through that process, I learned a whole lot about e-commerce, the ecosystem, what to do, what not to do. And along that ride, I met the founders of Website Closers, Jason and Ron, at a mastermind that I was facilitating, and ended up joining Website Closers a couple of years ago. And now I've had the opportunity to not only have exited my own business, but also guide that of a number of clients through the exit process. And was asked today to kind of serve as a guest facilitator about patent infringement and the Amazon process and that sort of stuff. So unless there's further introductory or commentary, I figure I'll just jump right into it. What do you guys think?
Sounds great.
Awesome. Tom, tell us a little bit about the Amazon patent infringement process. Give us the lowdown, please.
So thanks, Dave. This is something that is starting to come up more and more. as a brief overview, if you have a patent or someone owns a patent and they believe your product's infringing, there's traditionally the normal way you would go about doing that is either communicate directly with them or file a lawsuit in federal court. Amazon, with its vast amount of products on it as well, has gotten a lot of slack for allowing multiple knockoffs to infringe on intellectual property rights, particularly on patents. So about 2 years ago, year and a half, 2 years ago, they decided to roll out basically kind of their own internal process on how to determine whether or not a product is infringing on a patent. And they've gone through this, and it's now also, as Amazon does, that's starting to get a lot of slack as well, because they don't seem to know how to not overcorrect, if you will. So what they've done now is they've taken a little bit of a staunch stance, and if somebody has a patent, basically it's up to the patent holder to enforce their rights. So they would make a claim with Amazon saying, hey, we believe that this product's infringing on our patent. Here's our patent number, so on and so forth. What would then happen is then the Amazon would basically send that over to the other infringing product to say, hey, are you infringing or not? They have the opportunity to respond. If they say, no, we're not, then the patent holder can then initiate kind of this internal patent process evaluation with Amazon. And it's allegedly using a third party that Amazon kind of picks, and they analyze the information that is sent, the patent, the product. There's a fee associated with it. It's much less expensive than going through the court process. And then what happens is the infringer gets an opportunity to try to respond for that. If the independent arbitrator decides that it is infringing, then Amazon is typically, although they do say they like to see a court order, they're not requiring it. And so then you'll start to see some level of arbitrariness of them pulling down the products. Sometimes that's a good thing, sometimes it's a bad thing. But the internal workings of how that internal process works, they're keeping very close to their chest. They're not disclosing it, they're not really being transparent about how that process works. And so it's leaving a lot of customers, a lot of sellers, a lot of business owners a little bit in the dark about how that works and what to do if that does happen.
Thomas, can you tell us a little bit about what happens on the accused or the accuser side, both, if they ignore the process?
Yeah, so silence is not your friend in this case. If you get a notice from Amazon that you are potentially infringing on a product, not responding will basically default that you are infringing or you're not willing to fight it, and they're going to side with the patent holder in this case. So if you are actually infringing, then maybe that's a good thing, and you got caught and you move on to the next thing. But if you don't believe you are infringing, ignoring it will certainly result in your listings getting pulled down, and then you have to fight very hard to get them back up. This is not a knock on the door and say, hey, just kidding, we'd like them back up scenario. Sometimes you have to even go through the arbitration process, and it's difficult because Amazon does, and there's a lot of case law around it, they do have pretty much unilateral control on what products and listings are on their site. So it is very important to follow their guidelines, because if they decide they don't like you and they don't want to keep your stuff up, there's almost nothing you can do. It's very difficult.
And how does the process differ from using the court system?
So the process differs in many ways. And just to step back very briefly, the reason Amazon takes this approach is when you're dealing particularly with patent infringement, and this also covers trademark infringement, every party along the chain can be held liable. And so what Amazon's trying to do is they're trying to avoid being caught up in a patent infringement liability scenario. So as you can imagine, if you're Amazon, you're going to default to, how do I not get caught up in this, as kind of your default reaction. And so, and the court system, certainly the courts do not have that worry. So they look at the case much more closely, with much more scrutiny. There's much longer and drawn out process. It does follow pretty much a federal litigation case. There's some nuances within patent law that do add to the complexity of it. But you're really looking at whether or not it truly infringes or does not infringe. There's typically experts involved and things like that. The difference there is that process from start through trial and appeal could cost $1.5 million to $3 million of attorney's fees on both sides. Most small businesses, most businesses in general, are not very thrilled about that prospect. So Amazon's trying to create something, right? So I think give them a little credit for trying to do something that doesn't cost 7 figures to get to an answer. But at the same time, they are being fairly arbitrary with this. We don't know who the arbitrator is. We don't know their qualifications, right? They're not being very clear about that. And so it does leave a fair amount of ambiguity. And if that independent patent evaluator is wrong, reversing that is sometimes you have to just go to the court system. It becomes a little bit more difficult.
Got it. Has there been a time when Amazon has not followed their own process?
Yeah, so they have very unique language in their agreements, and so they can violate a clause and then claim that another clause is what they were following. So they have these catch-all clauses that at the end of the day, they have clauses saying, well, this is how this process works, and this is how we have to react, and this is how our sellers have to react. And then they have a catch-all that says we can still do whatever we want. So, it becomes tricky because what do you follow, right? Because if they do make a mistake, they just lean back on this, well, we can do whatever we want clause. And so it becomes tricky. Now, they will oftentimes recognize their mistake if you yell loud enough and be hard enough. But that costs money too. You got to engage with a law firm, and you got to go after them, and you've got to push their button, right? They're pretty good about eventually getting your listings back up. Getting your lost damages, though, is nearly impossible. There's very little liability on their part because their contract is so one-sided that it's hard for them to do much to violate it. So they have to do something incredibly egregious in order to create some sort of bad faith element, which then could qualify you for damages. And it's just very difficult to do.
So what's the process if they do, cite one of their catch-alls and they're somewhat contradictory to themselves? Like, how do you navigate that? What do you do if something like that happens?
So I think you have to set expectations. Expectations are going to be, we're going to fight back to get our listings back up. And as long as we think we're in the right and we have a good faith basis for that, you probably can get there, right? So that's where you can probably get. But there's really not much that you can do at this point unless something at the congressional level or the federal level changes at some point. Because if they pull you down, you're kind of SOL on that. And they're not going to reimburse you for your lost sales. They're not going to reimburse you for your lost marketing, for your loss of positioning on that product page. And it becomes tricky. The bigger, broader question becomes, is there some governmental oversight that is needed with some of these tech companies simply because there's such a monopoly now, right? I mean, if you're selling e-commerce and you're not on Amazon, you lose 90% of the market, right? And same with Google, same with Facebook, same with Twitter, right? So they're private companies, of course, right? So that's why they're able to do these things. But it does beg the question, is there some additional oversight that should be put into place because the drastic effect, they can put a small business out of business overnight if they click the wrong button.
I think of Amazon's kind of like those old school malls, but they also own all of the real estate too. So if you're the shop owner, they own the mall, they're directing all the traffic into the mall, and they erect a barricade around your storefront.
And now they're opening across the street, across the hall, a store that sells the same products as you. So it's like,
and possibly owned by Amazon.
Yeah.
Correct.
So there's no government authority you can go complaining to when your landlord, has locked your doors, kicked you out, and they've opened up their own store across the street from you.
Because they say, well, you can go open up somewhere else. And technically you can, right?
Yeah.
But if 90% of your business is going to the one spot, is that really an option? I mean, I guess, technically yes, but it's hard.
Let's switch gears for a second. Shelley, how do the product takedowns concern buyers, like in due diligence? And let's talk a little bit about, if there's an effect on sale price and stuff too. Like what's the thinking around all of that?
So as you can imagine, if you are getting ready to buy, and I think a lot of, there's aggregators of businesses, of Amazon businesses and of e-commerce businesses, and there are also individual buyers, and you're getting ready to buy a business, and their hero or their top seller item has been taken down. Why? Alleged patent infringement or alleged trademark infringement. Needless to say, those sales are no longer available when you do the math and you model what the value of the company is. If you were going to get a 5 times multiple, okay, it's 5 times, but you have to reduce this seller's discretionary earning. You have to reduce the revenue by the amount of those products which are no longer being sold. So needless to say, it's a huge valuation problem. But add to that the complexity of it was taken down and I got it put back up. It's still a history discussion. When you do a transaction, the buyer has lots of questions. They do due diligence. They look at how you've operated your business. If you have a history of a lot of product takedowns or a lot of product suspensions, it impairs your total value because the buyer is looking at that and saying, this is an incident waiting to happen. This is a situation where Amazon might get frustrated with this brand, might get frustrated with this product line, might get frustrated with this seller and the seller central account. And even though it's fine now, I don't know, I'm not confident, I'm uncomfortable with whether it'll be fine later. We've even seen situations where a similar product from another seller was taken down and the buyer has now gotten nervous and said, well, what confidence can you give me, seller, that your product won't be subjected to this infringement claim, won't be knocked out by an alleged patent or the same patent holder? It's really a complicated situation. We've had situations where we're in the middle of a deal and everything's going great, and we get a demand letter from somebody who claims to have a patent and is threatening an Amazon takedown. Sometimes you can't even figure out who the seller is. They don't even really tell you who the patent holder is, or it takes a little time till you get the information. You pull it together, and first thing my client does is said, well, this isn't true because I buy my products from a manufacturer, and my manufacturer has told me it's not infringing. We go back out to the manufacturer. The manufacturer is in China, perhaps, not always, but often in China. And the manufacturer says, yeah, well, they like to complain about that issue, so we'll just change a couple of things about your product in the next shipment and it won't be infringing anymore, or they won't be able to claim it's infringing anymore. So now I have somebody who's trying to buy this business, and the discussion is, can we tweak it? And Tom, you may have an opinion about this, but there used to be an old joke that if you changed every 7th note of a song, you weren't violating the copyright, right? You weren't violating it, it wasn't infringing. Well, so if you take a string of Christmas lights and you change every 7th light, does that mean that you no longer have an infringing string of lights? And that's what these Chinese manufacturers are doing. They're literally reverse engineering and trying to work their way around what they think the patent holders are going to say. It's become a major issue in the negotiation and the understanding between buyer and seller of what your rights are. Now, I'll just add one other element to this. Keep in mind, when you sign an agreement to sell your business, there are something called representations and warranties. And standard is a representation that says none of our products are infringing. And when you go to a buyer and say, I'd like that to say, to the best of my knowledge, none of my products are infringing. Most buyers push back and say, no, this is your problem, not my problem. I'm going to buy something and I need to know for sure, not infringing. I'm not willing to live with best of knowledge. So it becomes a major negotiation. Now you're way down the path with your buyer. You're close to closing the deal and you're in a major fight over that kind of language and over your own confidence about whether or not you have products that are infringing someone else or that there are other people infringing your products, because both will be in that agreement. And so it's become a really hot topic in the M&A world.
And so one potential resolution in that process is having additional escrow or having holdbacks. Can you talk a little bit about how maybe some of those have evolved in a negotiation last minute?
Sure. That is exactly what happens, Nate, as you know, and you and I have been to that dance together, I think.
Yes.
But yeah, when you start to see a situation where there's a potential for infringement or some uncertainty, and the buyer is still ready to go forward, maybe it's a minor product instead of a major product, maybe it's something where there's greater confidence that there's really no infringement. A lot of times what you'll see is that the buyer will say, I want to hold back a piece of the purchase price for indemnification and for this risk. A seller might say, well, I don't want you to hold it back. I want it to be put in an escrow. I want it to be actually money upfront held by a bank so that we both know it's there and available, because I don't want to wait a year or two to find out you don't have any money and you're not going to give me my holdback, even though nothing went wrong. So, there's a little bit of a tug of war over how that happens. Some buyers will refuse an escrow. Some will say, okay, yeah, I can do that. It works. But now what that really means is the purchase price you get at closing is a lower dollar amount than what you were expecting. And I'll just point out, with Nate here online with me, you've got a broker in the deal. If you do have a broker on the deal and your agreement, the listing agreement with the broker provides for payment based on the total value includes the amount of the escrow and the holdback. So you may have, due to your broker, upfront an amount that assumes that holdback and escrow will be paid, and it may be due to be paid at the time of closing. And I point that out, not to pick on brokers, but to be clear what's expected. We've had the situation where by the time it's all negotiated, the amount of money the seller is going to get is severely reduced because of holdbacks, escrows, later earnouts, broker payments, amounts they owe to perhaps their lenders. And so the amount that they're actually clearing at closing is quite small. And we find that sometimes the seller says, well, if that's all I'm getting, I don't want to close the deal. It doesn't work for me anymore.
Yeah, the more transparent we can be about the financial situation going into it, what the goals are, the better. Because deals, they wiggle as the process goes along, and no one wants to be in a situation where we're having a, last minute tug of war. That can be challenging for everybody involved.
Yeah, I'm a big fan of disclose early. If you know you've got a problem, if you know there's a situation, disclose it early, because if your buyer is going to get nervous about that situation, we want them to get nervous early because we want them out of the deal to move on to somebody who won't be nervous. Sometimes, and Tom, you've been a great partner for me in this. Sometimes we have these situations and I've been able to pick up a phone and call Tom and say, hey, what do you think? And he's able to negotiate and navigate a solution as a patent attorney, or able to provide us a written letter that indicates there really is no patent infringement, and we're able to knock out the problem, and we can knock it out early enough so that we can get over the hump, we can get the deal closed. But I'd rather to work on that part early, because after you've been doing the dance on diligence and trying to get to a closing for 2 or 3 months, to have an issue like that come up after that spending, people are just exhausted and it causes deals to fall apart. Whereas if you deal with them early and upfront, often those deals go through and it really doesn't even delay a closing.
Tom, let's switch over. How can you be proactive in protecting your client's interests? Or how can your client be proactive in protecting their interests?
Yeah, so I think it's important to think globally here, which ties in with what Rochelle was talking about as well. So there's nothing any attorney or any of us can do to eliminate your risk of being sued, right? What we can do though is we can reduce the percentages, right? We can give you an ability as a business owner to make a decision knowing, okay, I have a high probability, a low probability, something like that, right? So all of these things that we're talking about are not ultimately eliminating the risk we're discussing. They're giving you knowledge so that you can have a degree of probability of likelihood that it will happen, likelihood that it won't, and if it does, what's your likelihood of succeeding through it. So I think that's important because a lot of what we're talking about here is you could have a product that's an exact infringement on a patent, and if that patent holder chooses to never enforce it, you don't have a problem, right? And you could also have a product that doesn't infringe but is close enough, and you have a patent holder that's very uber aggressive, and you do have a problem, even though ultimately you're not infringing. So a lot of this comes down to posturing, business decision, and things like that. So when we talk about what can you do to protect and be proactive with that, the first thing is to think about is the best defense is a good offense. And how do you get a good offense? Well, if you don't have trademarks filed, if you don't have any patents filed, right, things like that, that's something that you should certainly look into, because you can have a product that you're very closely mirroring, but it's got some significant changes to it. You can file for some protections on those significant changes if they're patent eligible. And if someone then comes at you saying, hey, you're infringing on our patent, it's a lot stronger, better position to be in to say, actually, we think you're also infringing on our patent, right? A stalemate in these situations generally results in a settlement of some sort, or a deal, or a cross licensing, or something like that. But if you're stuck with no IP protections and you're just trying to put up your shield to block them, at some point, something's probably going to get through. And so that's generally the best way to be proactive. Another good way to be proactive is to do a little more due diligence, especially if you're buying an e-commerce company, right? Don't just go in and say, hey, are we good? And they go, yeah, we're good. And then go, all right, let's go forward with the deal, right? Hire your own counsel, do some searching, do some preliminary things where I'm not suggesting you have to spend, $200,000 to do a complete global freedom to operate search and opinion, but there are certainly some things that you can do to get a preliminary assessment on, okay, are there any glaring elements here that we're going to run into right off the gate?
Like a Google search.
Like a Google search.
For crying out loud, let's at least look at the first page of Google.
Like a Google search, an Amazon search. Who else in your product category will you be competing against right off the bat, right? Look at those sellers, look at their products. Do they say they have patents? Do they say they have some stuff? That's an easy thing for us to then go and look at that patent. And now you're spending a few $1,000s, up maybe 5, maybe 10, but it's very manageable if you're buying a company to make sure that you're at least knocking out some of the big obvious ones. So that's a big part of how to be proactive.
What's the most cost-effective way to use patents and trademarks to your benefit? Like if you own a company, you're reselling products, to create some defensiveness around it.
So there's a couple variations between trademarks and patents that are important. So one is on trademarks. If you have a trademark and somebody's infringing on it, the way the law is you have to do something about it, or you will lose or dilute your rights. Because the whole purpose of a trademark is so that a consumer, at least in the US it is this way, in other countries it varies slightly, but in the US it's consumer based. So the whole point of trademark law in the US is a consumer sees your product with your brand, and if they see another brand with a similar product and they think that they're related, affiliated, similar, and they're not, that creates dilution, because now there's a brand, right? If I go to McDonald's, whether you think it's great food or not great food, you pretty much know if you go to any McDonald's around the country and probably around the world, you're going to get a very similar product. If there was a McDonald's that was of a different product level that was not the same, it would confuse consumers. They would think that they're getting the big McDonald's when they're not, right? So that's the purpose of trademark law. So what that does force you as a trademark holder to do is, if you see an infringement, you need to act, or you're going to run the risk of dilution and potentially extinguishing your rights on that trademark. So that's important.
Yeah, and Tom, before you jump into patents, I just want to add to what Tom said, because it's also very important from a value proposition. If somebody's buying your business and you own a trademark and you've protected your mark and you've protected your IP, there's more value there to that business owner. If you've got a mark that you have let other people infringe, or that has deteriorated in value, it's a problem for the buyer, because the buyer isn't going to put as much value on a mark that looks like somebody else's, that hasn't been protected, that may no longer have the effectiveness or rights of effectiveness that that you're trying to sell. And so I think the points that Tom is raising is not just about current operations, but also long-term value. Sorry.
Yeah, I can comment on that too. As a marketplace for these, we see the utility patent is like the gold measure. Like, buyers really like utility patents. Then the design patent, then the trademark, and then copyrights. So in that sort of order, we see buyers expressing interest at the utmost level for utility patents, and then the design patents, and they are worth more. Those businesses sell faster, sell for higher. We had one that sold at an insane multiple, partly because of the patents associated to it and the sales velocity, and then the social media presence for it. Like, it's all surrounding branding and those trademarks and patents in enhancing that brand.
Right, it helps differentiate your brand from everybody else's. And even when you have lookalike products, people will still tend to the brand they know.
Yeah.
So,
and if you think about it from if you Google and your brand is number 3 or 4 or 5 on the organic results, right? And other similar names are popping up ahead of yours, right? It's less likely that you're gonna, people are more likely to click on number 1 or number 2 if they're looking for you, than scroll down the page. Same thing with social media, right? If you have a bunch of social media handles that are all really close to exactly what you do, selling a similar or same product, again, you didn't enforce your brand, you didn't clean it. So that's also why you see these big guys, the Apples, the Disneys, the Nikes, very aggressive with their brand protection. It's not because they hate you. It's because they don't want to lose their dilution, and that's a risk that they run. And so that's on trademark side. And on the patent
also
side,
one more on trademarks. I keep interrupting you, but one other thing we've seen with trademarks is, if you do own a trademark and somebody tries to take a domain or tries to use on their website a mark that you own, or a name that is very similar to a mark you own, you can often get the host to take that website down. You can also force the domain to be transferred over to you. But if you don't own the trademark, domains are not protected, and anybody can own a domain name that's not protected.
Right. Yeah, and so it gives you this ability. It gives you more tools in your toolbox, right? And so switching to patents, the big difference with patents is it's a monopoly. So you do not have to go after somebody if you don't want to. You can sit and watch and wait, and your rights do not erode. So what's an example of that? You could have somebody infringing on your patent, blatantly copying it exactly, and you can sit and watch them while they try to gain traction, and you could wait 10 years. As long as your patent's still valid, then you could decide, okay, they've made a bunch of money, I'm gonna now go after them. Now, what waiting does do to you is it could limit your damages calculation. A lot of times they'll only let you go back about 6 years or so in terms of lost revenue, but you don't have any requirement under patents to do it. So speaking what Nate kind of talked about, why the utility patent is kind of the gold standard, is because one, the utility patent is about the functionality. It makes it harder than a design, like a design patent you can easily work around. A utility patent makes it a little harder because it has the ability to cover more subject matter. So that's one. Number two is you're in control. You get to sit there and decide when you want to go and enforce it. You're not forced to do it. The only thing you're forced, or the only thing is the time, the clock's ticking. So it's 20 years from the date of filing is when it expires. And then you have a 6-year statute of limitations after that 20 years to then go after somebody if they were infringing while the patent was active. So it gives you a lot more control. And that's why you're seeing buyers value it a lot more, because you can use it for a threat of litigation. You got to be careful with that, but it happens a lot. And when you're talking about a small or mid-sized company, the prospect of them having to spend 7 figures on defending this, it deters a lot of people. And so it does hold a relatively big stick when you do that. But so those are very important differentiations, to do. And so, if you build some sort of a portfolio of IP, whether it's patents, trademarks, even copyrights, if it's applicable, you create that kind of moat that buyers really want to be in, right? Because a buyer's buying you, and if you can reduce the risk of their purchase, you get more money. I mean, it's just that simple, right? And if you have high reward and no risk, you get a lot more money than if you have medium reward and high risk, or medium reward and medium risk, right? And so it's all about reducing the risk, and that's what owning IP does. It's an investment. Some of it's not very cheap, but depending upon where you're taking your company to, it creates that moat around your product set, and it gives you the ability to reduce risk, not only for yourself, but for any potential acquirers.
Yeah, and there's a nuance to this in the M&A world. A lot of our clients will work with independent contractors and employees to help develop that IP, who will help them engineer it, or in the case of copy, who might write it, or in the case of graphic designs, or photographs, might take those pictures. And the general rule is the inventor, the artist, the author owns that intellectual property. Whether it's registered or not, it is owned by the author. And when you think about that, and you think about that author creator as owning it, if those people are your employees, are your independent contractors, or third parties you work with, even your favorite brother-in-law, whoever it is, when the buyer comes along to buy the business, they want to see paperwork. They want to see signed documentation that the work was made for the company, that it was paid for, so it was work made for hire, that there was consideration given, and that the person receiving that consideration, that creator, that author, that inventor, is signing off and agreeing that the company now owns that asset. And I raise that as something very important, because we often get to the finish line in a deal and we're on closing documents, and the representations and warranties say, I own all of the intellectual property. And then the buyer says, please provide us assignments of all the copyrights, of all the logos, of all the trademarks, of all the photographs on your website, all of the copy that is written, the designs. Oh, you said your brother-in-law helped you design the magic cup that is so valuable. And our clients as sellers often say, oh, I don't have that kind of paperwork. And we're scrambling at the 11th hour trying to build that paperwork. Sometimes it's easy, sometimes not so easy. Sometimes you're going to find somebody you worked with 10 years ago and not so easy. So I would encourage you to think about all of this intellectual property, making sure you know who owns it. When you go to register your mark, or you register that patent, or if you have co-inventors, we want clarity about who owns it and who has the right to sell it. Because as valuable as it might be in your ongoing business, if you're going to get that hefty multiple Nate was referring to, it's easier to get the hefty multiple when you know you can transfer that intellectual property free and clear, and the buyer's comfortable with those transfers.
And real quick on that, Rochelle, on the patent side and the trademark side, there's a governmental system that's built in to say who owns what. And so that's relatively easy to identify if the things have been done properly or not. Where the contractual side, which you're talking about, really comes into play is on the copyrights and the trade secret side, because those are things that oftentimes copyrights are not filed for things that aren't considered works of art, even though there's a copyright element to it. And oftentimes trade secrets, well, always trade secrets are not filed, or they wouldn't be a secret, right? So those are the two things that oftentimes get caught up in this as well. And so a lot of times too, to piggyback on that real quick, is the owners, the founders, oftentimes never sign over an IP rights assignment over to the company.
Right.
So that's something that can get missed a lot as well. Now that's typically an easy thing to do, but you know, there are scenarios where attorneys would come up with scenarios. Let's say you have 3 founders and one of them passes away, right? And now that happened 5 years ago, and now you've got to try to get their estate to sign an assignment agreement for their IP rights, you know? So it can get a little murkier. And so those are something that are important to look at as well.
Yeah, and I would throw into your category of important are photographs, because a lot of our e-commerce sellers, especially Amazon sellers, have photographs on their website, have video on their websites, on the Amazon sites, and they may have somebody in their family who took those photos or videos, and that, you know, even though you think they're owned by the company, it was a friend, they didn't charge you. What you think, well, it's my product, obviously they can't just use it somewhere else. Well, actually, again, the video or photographer would be the one who has the right to use that.
Yeah, absolutely. And we
Very
run
good.
into that a lot, so, but go ahead, Nate.
Okay,
Yeah, I was going to ask, do you guys do Q&A at the end, or do you?
Yeah.
Got more questions we haven't hit yet, but if there are people that want to ask questions,
yeah,
is that
I see that
appropriate?
yep, I do. I see we have one question, and I thought maybe why don't we do it at the end? Why don't we can move over to questions, and
Yeah, we can do a Q&A as soon as this is over.
okay, yeah, and I would say in this case, it's somebody who says she's looking at helping her company and is
I think they've got a request for follow-up is what I took that as.
that's a request for a follow-up. So we will we'll come back to that follow-up. But in the meantime, why don't we keep going? And what I would recommend is if you do have a question, you can raise your hand or put it in chat, and we'll pay attention and we'll reach back out to you and give you a chance to ask your question.
If you're watching this later on my YouTube channel, you can leave a comment below, and we'll get back to you that way too. Can we talk a little bit about the Amazon brand incubator and using that as a way to jumpstart protection, or what kind of how that looks?
Sure. You know, we've had some clients work with it. I don't know, Tom, if you've worked with it much, but Amazon has a brand incubator that enables you to essentially get your trademark filed quickly and puts you almost immediately on brand registry. So for those of you who do business on Amazon, one of the things, you know, it's important to be on brand registry, because if you were on brand registry, I think we're still on 2.0 on Amazon, Amazon gives you preferential treatment. If somebody is using your brand, your images, your logos, you have the right to stop them if you're on brand registry and you own that trademark, and Amazon will work with you to do that. So what Amazon has done is they've created this incubator, and they charge, you know, a pretty close to what we charge, frankly. I mean, I think they charge $600. I think we charge, I don't know, $750 or $800 to do a trademark. And they get you your trademark and you're immediately on brand registry. It sounds great. The problem we've run into as a law firm is that often they file that brand, but they're not doing any diligence. They're not going out and getting that third-party report to see if there is a similar trademark out there, or if there's a reason why your brand won't be registered. And so now you've spent money branding under that new brand. You've launched your brand under that brand, and you get down the road with USPTO, with the Patent and Trademark Office, and you're 6-7 months down the road, only to find out your brand, your trademark is never going to be registered. You might even find out that somebody will make an infringement claim. When it's been sloppy like that, we've often been called and said, well, what can we do now? And it's, hard, because you've spent money developing your brand, your look, your labels, your feel. I mean, this is, there's real money put into developing a brand. And now you're facing a scenario where USPTO isn't going to award that trademark. So my caution is, the good news, you get on brand registry fast. The bad news, you get on brand registry fast. However, it might not be everything you're hoping for with your brand registry. We do have clients that use it. We have clients that use it to get a mark started while they have a whole slew of other marks they may be working on with us, with the idea that at least the one mark gets them on brand registry early, gets them going, and then they worry about what their bigger brand and what everything else is going to look like over time. And so there's a little bit of method to the madness on how they go about doing that. But it seems to at least get them onto brand registry quickly. I don't know, Tom, do you have any experience with that incubator?
Well, yeah. So, I mean, I guess what I'd say too is another example of, I think, Amazon being well-intentioned, at least from the goal, from why they created this. And I think it's important to maybe understand the why behind it as well, because there is a place for it. I don't think it's a waste necessarily, but you got to understand what you're getting and be prepared. Whenever you pay less, you're expected to do more, right? So that's pretty common throughout all of this. And you can certainly do more on your own and end up paying less because your needs would be less, right? So Amazon created this because there's a lot of these, I call them trademark chop shops out there that aren't even law firms, that just basically put a GUI or an interface on top of the USPTO filing system. They portray as if they're helping you to file your trademark, but they're really not. They're really, you're submitting it. You're the one who's responsible. They're not the attorney of record, anything like that. And so that has been being used a lot by, first it was being blasted by Chinese companies in particular, foreign in general, but a lot of Chinese. And what was happening was the USPTO is getting completely inundated, and still kind of is. So then the USPTO made a change to say, you can't file for a trademark as a foreign citizen. So if you're not a US citizen, you are not able to file for a trademark. So you have to then hire an attorney. So that was one way to try to minimize that. Amazon said, well, let's create kind of our select law firms that can do this for you. And you can come through and it's kind of a fixed fee type scenario, better than the chop shop. But again, it depends on what you're trying to build, right? So if you are completely cash strapped, it's probably a great way to get started. And, there's some risks involved, but you probably couldn't afford to pay for a search on those, those risks anyways, right? So it can be a great thing from that perspective. But again, you're not going to get that personal touch that you would get with a, whether it's working with us or another firm that's going to spend a little more time with you, understanding what it is you want to do, making sure your description and your classes are correct, because that becomes a big issue. We see that a lot. We get clients that filed for a name, and in their description, they put the brand as the description of their brand. And lo and behold, it gets rejected every time. So a lot of times there's ways of putting a different description that gets them to the same place, but doesn't get a rejection back, right? So there's nuances within it that you typically are not going to get from either the brand registry or those chop shops, because they're just, you know, they just can't spend the time because it's just all about volume. So I don't think it's bad, but I think you want to understand what it is. If you've done the research and you feel confident and you've been through this before, and it's just a lower cost option to get you what you want anyways, absolutely, it can be a great option. But if you're unsure, if you want to be extra careful and make sure that you're not going to be infringing, you're not going to get a demand letter or a takedown as soon as you start launching your product and things like that, you probably need a little bit more TLC around that, and make sure that that we've kind of looked at this a little more holistically.
Very good. Guys, do we want to do a little Q&A? We've got about 7 minutes left here. I've got a plethora of questions. I can just keep going too. What's Tom and Shelley, what are your preferences?
Yeah, happy to do Q&A. If somebody at the bottom of your screen, there should be a raise hand button if you have a question, and I can open up the microphone so you can ask directly, or you can put it into chat. If you don't, I'm going to let Nate keep going.
Yeah, we'll wait for that. If someone's got a question after this next question, we will circle over to you.
And if you want one-on-one or questions after, I'm sure Rochelle is too. I'm happy to
absolutely
discuss
as well if you have a specific question you're not comfortable asking in front of the group.
And likewise, any questions about valuations, I'm here to serve as well. That's my bread and butter too. Are there instances, Shelley, have you had to go on the offense on trademark attorneys regarding bogus trademarks or bogus filings?
Yeah, I shared this story with Nate, so obviously it was a setup question, but we were on the verge of closing a deal. And this was a number of years ago, and my client did not have a registered mark. They had a solid brand worth a lot of money, but he didn't have a registered mark. He had been given the advice by a trademark attorney that he couldn't get his mark registered for a variety of reasons, which I can later debate whether or not that was right, but and later proved that his trademark attorney was wrong because we got him a registered mark. But what happened is we were literally on the eve of closing when the buyer did a trademark search just before closing and said, somebody has a registered mark and it isn't you, and it's for your brand. And we immediately jumped in and looked. When we looked at it, there was an attorney of record. Remember what Tom was saying about foreign attorneys. So we have this foreign holders. We have a US attorney with a foreign person as the owner of this trademark. And lo and behold, it is not just our same name, but it's actually used in its trademark application, pictures of our product, of our client's product. The front and back label of the product show in the trademark application, because you have to show that it's commercially available for use. So I immediately got online and tried to get a hold of this attorney. And of course he doesn't. I write him a pretty scathing letter saying, can you explain, how you filed a trademark this like 2 weeks ago for this brand for people who are not the brand owners. And the guy didn't really respond. We gave him 24 hours and I said to him, look, I finally call his office. He finally picks up and I said to him, look, you signed this application, Mr. Attorney. You certified as the filing attorney that this is your client's product, yet the pictures, and if you look carefully and you zoom in on the back of the label, you can actually see not only my client's name and my client's address, but you can see that this is clearly not your client. And this is clearly not who your client claims to be. And they have hijacked my client's pictures and brand and tried to file a trademark. And the guy said, well, I don't know. I have to look into it. Within about 16 hours, I also said, well, look, you look into that, but I'm getting ready to file a grievance because you need to get this application taken down and you need to abandon it. And he said, well, you know, I just go based on what my client says is okay. And so I said to him, look, you need to take action on it. This is just not appropriate. It's very clear your client doesn't own this mark. And about 16 hours later, he has resigned as the attorney of record from a whole bunch of files that were done for the same company out of someplace in Europe. We're trying to figure out if they were in Italy or Nigeria. It was very unclear as to where they were. They had all sorts of kind of unusual addresses, but they were clearly the same company. And then it took a little bit, and sure enough, they abandoned the mark very quickly. I don't know if he got his client to do it or if he just did it based on his own determination that it was not a legitimate filing, but they abandoned the mark, and we went ahead a week later and properly filed the mark for our client. It almost killed the deal because it's the main brand that they were selling. It almost killed the deal. You know, tens of millions of dollars of purchase price, and the deal wouldn't have closed. So I just alert people to really something Tom said about going on the offensive. Be aggressive. If you're using a name, if your name has value or you want your name to have value, get that trademark filed. If you're using a name and it normally ends, you know, there's already a trademark, you know, I'll use the word kicks. If you're using a trademark and there's already a trademark called kicks, K-I-C-K-S, and it's for, you know, a ball. Shoes, okay. And you think you're going to go file a trademark called K-I-X or K-I-Z-X or something like that, or XZ or XS, and you're going to get the trademark, there's a high probability you're not getting the mark. Even if you by chance get through USPTO and get the mark, there's a high probability somebody's going to be coming around the corner to take you down if it's for the same category, if it's for the same products. I mean, if you're filing a mark for kicks and you're, you know, and it's on a computer, you know, or on a, you know, I don't know, some other, you know, for a key fob or something like that, you know, maybe it'll be fine. It's a different category. But if it's the same category, if you're trying to go after your competitor, I would be really careful about getting too close in the name, because you're likely to be taken down. You're likely to be found infringing. And if you have attorneys like Tom and me on the other side, there's a probability that we're going to go after it pretty aggressively if we're in the middle of a deal and we see these problems.
Guys, we're at the top of the hour. Tom, do you want to comment on being aggressive, being proactive?
Yeah, I mean, I think maybe I'll just close with, you know, a lot of this is about avoidance, right? So, you know, everyone complains about attorneys' fees and costs and things like that. And I certainly get it. Being a previous business owner before law school, I was on the other side of that. So totally understand that side of it. But, you know, was the penny wise, pound foolish kind of saying, right? So everything we're doing on the front end is to avoid the big numbers. The big numbers are getting caught up in expensive litigation or getting your product taken down, right? I mean, those are kind of the big killers. And that's why due diligence on buyers, they spend so much time looking at those things and seeing, you know, what are the risks of litigation? What are the risks of my product being taken down, so on and so forth. So I would just say that, you know, consulting with a good attorney, a good firm, will save you a lot in the end. You might spend a little bit more upfront, but if you have your ducks in a row, you're prepared for these types of scenarios, right? And if you have protections yourself already in place, even if you happen to be infringing on somebody, you at least have you know, a swing at the bat, so to speak, that you can take, and that's going to be a heck of a lot better than if you're sitting there, you know, kind of naked with no protections in place, and you're just getting shot at by all of these alleged, you know, trademark and patent holders. And so At the end of the day, I think it's a game, and you got to play the game. And we have clients that they complain, they don't like the rules of the game. I didn't make the rules, right? Rochelle didn't make the rules. Nate didn't make the rules, right? But if you're going to be in the game and you want to make money and you want to do this game called business, you've got to play. You got to play the game, and this is part of it. And it's become more and more, and it's not getting less, because the more global our world becomes and the flatter it becomes in that respect, these are going to be issues that are going to just escalate over the next 5 to 10 years, and so you need to be prepared.
Absolutely. Thank you guys very much for inviting me on, and appreciate anything I can do to help your audience. Always Nate at websiteclosers.com.
Perfect.
And
It will be posted on YouTube channels after this recording as well. So feel free to watch it again or share it.
right. And I think it'll also be on our website. And thank you all for your time. Always a pleasure working with all of you. Thanks so much.
Bye.